Hello there. Well, what a surprise. A Brexiteer success in the courts, no less. You could have knocked me down with a feather when the news came through that Brexiteers had won a court case against the Remain campaigners. Who would have thought that? But a judge in the Court of Sessions in Edinburgh has rejected the case brought by Joanna Cherry of the SNP and others that tried to get the court to rule that Boris Johnson had acted unlawfully and unconstitutionally by proroguing Parliament for so long in the run-up to Brexit Day. The judge, Lord Doherty, said, "It is not for the courts to decide further restraints on prorogation, which go beyond those which Parliament provides." And that is the point. The Royal Prerogative can only be restrained by an Act of Parliament. It is otherwise open to the government to use it as required. But those bringing this case have not yet been deterred. They plan to appeal, and that could be heard tomorrow, or even, they say, this afternoon. Now, I bet there are many people around the country who wish their court cases could be heard that fast. One of those bringing the case, the Edinburgh South MP Ian Murray, said that the fight against the Prime Minister and his plans to, as he put it, crash the UK out of the EU would continue. And the director of the Good Law Project, Joe Lyon-Moam QC, said that if the government can prorogue for so long without court intervention, then it lets loose some ugly demons, and went on to say that if he can do it for 34 days, why not 34 weeks or 34 months? Where does this political power end? I think the judge set out the position there, and that is that it is up to Parliament to decide, not the courts. I think we should also consider that those seeking to diminish or nullify a prerogative power should be careful lest it turn around and bite them later when they end up needing it. The leader of the Scottish Green Party, MSP Patrick Harvie, said that this would leave open the route for a government to shut down Parliament indefinitely, so a future independent Scotland should have a written constitution that prevented such a thing happening, he said. Now, Lord Doherty also said that, "In my view, the advice given in relation to the prorogation decision is a matter involving high policy and political judgment. This is political territory and decision-making, which cannot be measured against legal standards, but only by political judgments. Accountability for the advice is to Parliament and ultimately the electorate, not to the courts." He also said that the Prime Minister had not contravened the rule of law, and that the power to prorogue is a prerogative power, and the Prime Minister had the viris, that means the power, to advise the sovereign as to its exercise. Now let's hope the same is said in the appeal, as well as in London and Belfast when those cases come up. Then how about rejigging the current political programme a bit and bringing forward the prorogation to Friday to cut the legs out from under this traitor's surrender bill about to be debated in the Commons this afternoon before it gets through the Lords? Anyway, what do you think? Please share and comment, and thank you for watching. Please do like and share this video, and also subscribe to my channel. And when subscribing, please do remember to press on the little bell next to the subscribe button. That way you'll get an alert every single time I put up a new video. Thank you very much for watching.